Hello there. I'm attorney Kelly Longtin from Kelly Longtin Law, and where we handle our firm focuses solely on estate planning. So I've created this on-demand webinar for all of you that don't have the opportunity to attend a public webinar. So a little bit about myself before we get going. So right in front of you, you can see where I was educated and a little bit about my bio. So the only area of law I've ever practiced in is estate planning, and I hope that you guys will find this webinar to be useful in helping you to decide what makes sense for you and your family. So it's always been my goal to educate people in the community about the benefits of estate planning and the options that are available to them. So I'm just grateful that I have the opportunity to educate all of you as well. So the information in this presentation is going to be explained in English, no legalese, so that you can better understand the information. So as I mentioned a moment ago, at Kelly Longtin Law, we focus solely on estate planning. I've been practicing in the area of estate planning my entire legal career, and I love that I have the ability to help families plan for their loved ones and to protect their assets in the event of an incapacity. And now everyone knows this about me, but one of the reasons that I'm so passionate about educating my community about their estate planning options is because of the experiences that I've had with my own family. As I'm sure you are all aware, not all families are created equal when it comes to planning ahead or even talking about planning decisions. And I definitely know this firsthand. Now you see in front of you, you see my family. My grandmother who was diagnosed with dementia, who has since passed away. You see my parents who I want to make sure are protected, and my children who I want to continually provide for, even when I'm no longer around myself. Now, I know from my years of experience that although every family is different in many ways, we do share very similar concerns about the people that we love. And I'm grateful that I get to share and host this video or on-demand webinar for all of you to help you understand the tools that are available to you, so that you can protect your family and continue to provide for them as you always have. So today you're going to learn about what an estate plan is, why you need an estate plan in place, what happens if you don't do any estate planning. I'm going to talk about your estate planning options, discuss probate and why you should avoid it. We'll also discuss incapacity in nursing homes and how long-term care gets paid for and asset protection. You're going to have a better understanding of the difference between a will and a trust, and the importance of powers of attorneys and the role that they play in your estate planning. But first, I want to talk to you and begin by talking about what is an estate. And although you may not be a billionaire, you all have an estate that needs a proper legal plan. An estate is just a general term used to describe everything that you own. This includes such things as bank accounts and real estate and your household furniture, automobiles, and then at your death, everything that you own has to then find a new owner. An estate plan is your personal set of legal documents that dictates what will happen to you and your money and your property at your death. And if you have a minor child, your estate can also allow you to nominate your child's guardian. Now, estate planning documents should also allow you to dictate what happens to you and your finances during any period when you could not make your own decisions, or if end-of-life decisions need to be made on your behalf. So let's talk about why people do estate planning. Now, most people do estate planning because they want to control who will receive their assets after they die and how they will receive it. And they want this to happen with the least amount going to legal fees and taxes. But estate planning is not just about what happens after you die. A good estate plan will also protect you at an incapacity. It will let you, not the courts, keep control of your assets and control of your decisions about your medical care when you can no longer handle your own affairs. It will also allow you to be able to protect some or all of your assets when an incapacity arises. Or maybe you're just worried about your children and what may happen if they get a divorce, or if you want to provide for your grandchildren. Either way, you're definitely going to want to listen closely to me. And now let's talk about who needs to do estate planning. And the answer is, quite frankly, everyone. Now, certainly the older that you are, the more you start thinking about how to transfer your assets to your grown children or your other loved ones. But families with young children, they need to do estate planning as well. And so do people who have children from previous marriages. Single adults, young or old, they need to plan too. So when should you plan? I get asked this all the time. The best time to plan your estate is now, while you can, and before you actually need it. Because with estate planning, there is no second chance. Now, none of us likes to think about our own mortality or the possibility of becoming incapacitated. And that's exactly why so many families are caught off guard and unprepared when an incapacity or a death strikes. So I want to talk to you about some common estate plans and the estate planning options that you have. And there's really only 6 basic ways for you to plan your estate, and one that's going to be the best fit for you based on your concerns. And the first is you can do nothing. The second is you can use joint ownership. Thirdly, you can give all of your assets away. You could also use beneficiary transfers if available. You could have a will, or you could set up a living trust. So I want to take a look at each one and see how much control they'll give you and how they each work. So the first common estate plan is to do nothing. But by doing nothing, you're actually leaving your estate planning up to the state in which you live. And if you have no estate plan, not even a will, when you die, then your assets will be distributed according to your state's probate laws. And if you become incapacitated before you die, then the court's probably going to step in and take control of your assets. Now, this is probably the worst situation to be in because you're not going to have any control or any say about who will handle your affairs when you pass away or where your affairs are actually going to go or your assets. So let's talk about your second estate plan option, and that's joint ownership. And it's one of the most common plans used by families. In fact, if you're married, you and your spouse probably own most of your assets jointly. This type of joint ownership that most people use is called joint tenants with rights of survivorship. It means that when one owner dies, the surviving joint owner has full ownership of the asset. Now, some people think that this will avoid probate and give them the control that they want, but it really doesn't. So I want to introduce you to Tom and Ann and their kids. Now, Tom and Ann, like most married couples, they own their home as joint tenants with rights of survivorship. Now, Tom dies suddenly in an accident, and immediately upon his death, Ann automatically becomes the sole owner of their home. There's no need for a probate. But what happens when Ann dies? Is there now going to be a need for probate? And the answer is yes, because that's the only way to get her name off the title and put somebody else's name on. So you see, joint ownership doesn't avoid probate, it just simply postpones it. Now, owning assets jointly can cause other problems too. So let's talk about what could have happened if Tom didn't die in that accident, but became permanently incapacitated as a result of the accident, or if he suffers from a stroke. How is Ann going to be able to refinance or sell the house? You see, because Tom and Ann own the house jointly, she's going to need Tom's signature in order to sell the house or to refinance it. And she thought if something happened to her husband, the house would go to her. And that's true if Tom died, but he didn't die. So she'll have to go through the conservative process, and the judge will oversee what she does with the money. She will have to use Tom's share of the house if she sells it for his care, which at this point would be nursing homes. Now, she's going to have the same issues trying to get money from Tom's IRA to survive and to pay her bills right now. Again, she thought if something happened to her husband, Tom, she would receive the money from the IRA. And again, this is true if Tom had passed away, but he is alive. And the only way that she can access the IRA money is to go to court, and the judge will oversee how she uses the funds. And she will only be allowed to use those funds to pay for Tom's care now that he's incapacitated. But what happens if Tom passes away, either from the car accident or a stroke, and Ann remarries and puts the house in joint ownership with her new husband, Dave? Well, if Ann dies first, Dave owns the house. Is Dave now under any legal obligation to give anything to Tom and Ann's kids? Absolutely not. The house belongs to Dave, and he can do anything that he wants with it. And even if Ann had written in her will that she wanted her share of the house to go to her children, it wouldn't have made any difference. Remember, wills don't control assets that transfer automatically to a surviving joint owner. So in this example, using joint ownership caused Tom and Ann to accidentally disinherit their own children. So the bottom line is that joint ownership can really cause a lot of problems. It doesn't avoid probate, it just postpones it. If you die first, you have no way of controlling what ultimately happens to the asset, and you could unintentionally disinherit your own family. And if your co-owner becomes incapacitated, you could find yourself with a new co-owner, that being the court. Now, adding a co-owner is easy, but taking his or her name off the title is not. And if your co-owner doesn't agree, you could end up in court yourself. And you could end up in a lawsuit if your joint owner is sued over an accident or that involves this jointly owned asset, or perhaps is in a car accident and then gets sued. You also expose the asset to the other owner's debts, and that property could be seized as a settlement. So let's talk about another estate planning option or strategy that comes up, and that's to give away all of your assets. So this is giving away your assets is an estate plan that a lot of people or older generations have used, and you can definitely do this, but I just want you to know the risks involved in doing so. So parents will often give their assets to their children, thinking it will make things easier if they become incapacitated and after they die. But what happens if you want or need that asset later? Will your children give it back to you? Maybe, maybe not. And let's talk about creditors. The minute you put your asset in someone else's name, you open it up to their creditors. What happens if your son or daughter gets a divorce or becomes separated and starts the divorce process? And what happens if you're falling out with your child? How do you legally get that asset back after you've legally given it away? And adding a child to a bank account, that has the same issues, and it won't help you protect assets if you become incapacitated. Medicaid will consider the bank account to be 100% yours unless you can prove that the money is not actually yours. And you know the old saying, never say never. Well, this is one time I want you to ignore it. Never give away an asset that you may need later, not even to your children. Now, I just want to take a moment to share a story with you about Frank and Elizabeth. Now, they're an elderly couple who put everything that they owned, including their home, in their married daughter's name. Well, a year later, after Frank did this, he passed away. And several months after that, unfortunately, his daughter passed away in a car accident. Now, Elizabeth never thought that she would survive her husband and her daughter. And now she owned nothing in her own name because she had put the house in the daughter's name, remember? And then she soon found herself in probate, now fighting her son-in-law over an asset that used to be hers. And right now she just didn't own anything. So you can see how dangerous that strategy can be. Now I want to take a moment to talk to you guys about taxes. Now I doubt any of you who are watching right now want to pay more in taxes than you already pay. And there's a big difference between giving an asset away versus inheriting it upon death. So here's an example. Let's just say that Bob bought his home for $100,000. And today it's worth $650,000. He then gives it to his son, Tom, who then sells it for $650,000. So you can see the basis, that's what he paid for it, is $100,000. He sold it for $650,000 and he profited $550,000. Because of that profit or that gain, he's then going to have to pay a capital gains tax. And the capital gains tax that Tom now needs to pay is about $110,000. That's what it is under current state law. But I want to take a look at what happens if Bob had left his home to his son, Tom, as an inheritance through either a will or a trust. So as shown here on the right, Tom sells the house for the same $650,000, but he received the house as an inheritance after his father, Bob, died instead of as a gift while his father was living. And the property receives what we call a new stepped up basis. Now the basis is now the value as of the date of his father, Bob's death, which is $650,000. So when Tom sells the house, there's no gain on the sale and there's no capital gains tax to pay. By not giving the house to him while he was alive, Bob saved his son Tom about $110,000 in capital gains tax. So let's talk about estate plan option number 4, and that's to transfer assets through beneficiary designations. And a common thought is, I don't need an estate plan or a trust because I have beneficiaries on my accounts. Now, many assets, including insurance policies and IRAs and retirement plans and some bank accounts, they let you name a beneficiary. And when you die, these assets will usually be paid directly to the persons that you've named as your beneficiaries without probate, but not always. Now, some common issues I see are if your beneficiary is incapacitated when you die, the court will probably take control of the funds for that person. The second issue is that if your beneficiary dies before you, or you both die at the same time, the asset will have to go through probate so it can then be distributed with the rest of your estate. Now, another issue is if you list my estate as the beneficiary. Now, the probate court will have to determine who my estate is. And if you list a minor child or a grandchild as a beneficiary, the court will probably get involved to protect the child's interest, even if the child's parents are living. That's because insurance and financial companies will not and cannot knowingly pay large sums of money to a minor. And also, relying solely on beneficiary transfers doesn't allow you to protect your beneficiaries from a divorce or if they have creditor issues, or to have control over the way in which your children and your beneficiaries will receive their inheritance. So you can see that there are definitely some major issues with relying on this method of estate planning solely. Now, let's talk about your estate plan option number 5, and that's a will. So some people choose to create a last will and testament to carry out their wishes. This document is also called a will. This is where you name your personal representative or executor. So just the person who's going to collect all of your accounts and property, pay all of your outstanding debts, and then distribute your money and property to those that you've named. So you get to specify which money and property will go where. And if you have any minor children, you also have the ability to name a guardian for your children. Now, although a will is only useful at your death, it's not useful during an incapacity, but a will does provide you a way to officially express your wishes in what you want to have happen when you're no longer here. So in contrast to having a trust, which I'm going to discuss with you in a moment, having a will to distribute your money and your property will require your family to have to go through the probate process. Now, that's a court supervised procedure that takes place to distribute to your loved ones the accounts and property that you own at your death. And if you don't have a will in place, the probate court will determine who gets your money and your property according to state law. But keep in mind, you will only control the assets that are titled in your name. Your will does not control assets that are titled in joint ownership and go to your spouse or another joint owner when you pass away. And it doesn't control assets with beneficiary designations, like your IRA, your retirement benefits, or your life insurance policies. Now let's talk about what probate is. I'm sure you've all heard of it. You don't always understand it or how it works. Now, probate is a legal process through which the court makes sure that after you die, your will is valid, your debts are paid, and your assets are distributed according to your will. A petition for probate will have to be filed. Personal representative or executor will have to be appointed. An inventory of all the assets provided to the court. There's attorney's fees and court fees and bond fees. And whether you have a will or no will at all, your estate will have to go through probate. And this is a notion that most people don't fully understand. People think that if they have a will that their family does not need to go through probate. But the purpose of probate is to change ownership of an asset in the name of the deceased into the name of the beneficiary. And the will just simply acts as a set of instructions to the probate judge. But it is only the court-appointed judge that can change title after someone has passed away. So when a probate is opened, then all of the debts of the person who dies becomes a liability on their estate. A publication needs to be put in the paper notifying the public and the creditors of the death of the decedent. Now, in Massachusetts, creditors have up to 12 months to make claims against the estate for the payment of debt. If the creditor does not file a claim within a year of death, then the debt will become uncollectible. Now, the executor or the administrator is what someone's called if there wasn't a will in place. They're responsible for paying any outstanding debts from the estate. And if no estate is left, then the estate is insolvent, meaning there's no money to pay off the debts, and the debt will usually just die with you. And probate fees are a big business. So a study showed last year that attorney's fees alone were as much as $1.5 billion, with hundreds of millions of more dollars going to bonding companies and appraisers and just the probate courts themselves with fees. Now, the costs vary from state to state. Some are statutorily required, but the usually estimated amount is anywhere between 3 and 8% of an estate's value. And if you own property in other states, your family could face multiple probates, each one according to the laws and the costs in that state. Not to mention, probate takes time. So even for modest estates, it takes 1 to 2 years to completely get through that probate process. It's extremely public, so anyone can find out anything that's going on and see who the interested parties are. And it can also expose your family to unscrupulous creditors and con men who use those probate files as a source to generate new scams and to take advantage of your beneficiaries. Now, the bottom line is that the probate process, not your family, has control on how your will is interpreted, how much probate will cost, how long it will take, and what information is made public. But there's another problem with the will, and that is it just doesn't protect you if there is an incapacity that happens, because a will only comes into effect after you've passed away. If you can't conduct business, think of this for a moment. If you can't conduct business due to a mental or physical incapacity, for example, was Alzheimer's disease or a stroke or a heart attack, only someone who's been appointed by the court can sign for you, even if you have a will in place. And having the court involved can be expensive and time-consuming. It's a completely public process, and it doesn't replace the death probate process that has to happen after you pass away. So let's talk about wills and minor children. If you have minor children or grandchildren and you have a simple will, which many people have, it may not give you the control that you want. That's because the court will control the child's inheritance until that child reaches legal age. At that time, then the child will receive their full inheritance. Now, this isn't what most parents or grandparents would want. Most would prefer that the court not have control over the child's inheritance and that the child inherit at a later age. But with a simple will, you simply just don't have a choice. Now, the last plan that you have when it comes to estate planning is a living trust. And a living trust is simply a trust that you formed and funded while you were alive. It's being used more and more by people of all ages and marital status and wealth instead of a will and the other plans or the options that I've just discussed with you. But before we look at the trust, I want to first compare a revocable living trust and a will. Now, both are legal documents. They've been around for hundreds of years. And in both, you name someone to handle your affairs for you after you die. In a will, this person is called an executor or a personal representative. And in a living trust, this person is called a trustee. And in both, you name whom you want to receive your assets after you die. But unlike a will, a living trust avoids probate when you die. You can control all of your assets during your lifetime, and it prevents the court from controlling your assets at an incapacity. A trust also gives you the ability to protect assets if there was an incapacity and a need for long-term care. Now, I know a lot of people are worried about nursing home care costs. I've been doing estate planning a long time. I have clients come in. For some of them, you know, on a scale of 1 to 10, it's a 10 as far as the importance of a priority. For other people, you know, it may be somewhere down a 1, depending on the situation. But I can understand why people are concerned about nursing home care costs, because the average cost of a nursing home in Massachusetts in the southern New Hampshire area is over $168,000 per year. So given that number, the next question is, so how would you pay for long-term care if it was needed? And if you haven't done the right planning, or you haven't planned at all? And first, the first way that you're going to use or pay for your nursing home care is to use all of your own money to pay for your care until you're nearly broke. But at over $168,000 a year, you can see how that might quickly bankrupt you and your family. Or you can try and qualify for a government program that helps pay for long-term care. Now, this program is called MEDICAID with an AID at the end. And MEDICAID is a joint federal and state program, which if you qualify for it, will help pay for your long-term care costs. But in order to qualify, you have to be nearly broke. Now, in a couple minutes, I'm going to talk to you briefly about Medicaid and Medicaid planning. But before I can do that, I need to lay the foundation for you about what a trust is and how a trust works. So to understand how a trust works, you just need to know these 4 legal terms. First, you have the trustors or the grantors. And this is just the person or people who created the trust. So for all of you, you would, if you were creating a trust, you would be the trustor or the grantor. No one else is ever going to be that party. Secondly, we have the trustee. And this is the person that you've chosen to manage all of the assets that you've put inside this trust. The next party is a successor trustee. So the successor trustee is just the person that you said, hey, this person will manage the assets that I put into this trust when I, as trustee, are no longer able to handle them, whether it's due to an incapacity or a death. And lastly, you have the beneficiaries. And those are the people that you've chosen to benefit from all of the assets that you put into this trust. So really, that's all you need to remember. You have the trustors, who are the creators of the trust. You have the trustees, who are the managers of the trust. You have the successor trustees, who will step in and help manage after you're unable to. And then you have the beneficiaries, who are the luckiest of all of these parties, as they'll benefit from all of the assets that you put in this trust when you pass away. And in a revocable trust, you still have full control of all of your assets. And as trustee of your trust, you can do anything you want with your assets that you could have done before you put them in the trust. You can buy and sell assets. You can change your trust. That's why it's called revocable. You file the same tax return, so nothing changes there. Your trust contains your written instructions for what you want to happen to your assets if you become incapacitated and when you pass away. You actually have more control with your assets in a trust than you would right now if you don't have a trust set up, or even if you just go with a will-based plan. Now, after you set up your living trust, your assets will need to be transferred from your name to the name of your trust. So for example, Bob and Sue Smith, husband and wife, to Bob and Sue Smith, trustees of the Smith Family Trust. Now, this is just what we call funding your living trust. Now, here at Kelly Longtin Law, we help each and every client with funding their trust to ensure that their estate plan is properly set up. Now, when you change the titles of your assets from your name to your trust, you technically no longer own anything. So when you die or if you become incapacitated, there is nothing for the courts to control. Now, the concept is very simple, but this is what keeps you and your family out of the probate court. Now, one of the most powerful benefits of a trust is, unlike a will, a trust doesn't have to die with you. Assets can stay in your trust, managed by the trustee that you select, until your beneficiary reaches the age or the ages in which you want them to inherit. And as we know, no matter what we do as parents, all children are different. Some are responsible, some are not. You may have a child who is a perfect poster child, financially responsible in every parent's dream. Or you may have a child who may be just a little lost in life right now. And the great thing with the trust is that you can decide how each beneficiary or child will receive their inheritance. Now, maybe you want to protect them in the event that they go through a divorce, or maybe you want to protect them from some poor decisions that they may make during their lifetime. You may even prefer to give children or grandchildren their inheritance in installments so that they might have more than one opportunity to use the money that's been left to them wisely. Even if you feel that your beneficiary would handle their inheritance well, you may want to keep the assets in the trust to protect them from creditors or current spouses or ex-spouses, maybe potential lawsuits, and maybe, depending on where you live, some future death taxes. Now, your trustee can make distributions to the beneficiary as needed, but the assets that remain in the trust would be protected from these creditors and predators. And if it was invested well, could even help provide for future generations down the line. Now, most people like to leave their children or their grandchildren with enough so they can do anything that they want, but not so much that they do nothing. Now, with the trust, you can do this and more. There's really no other estate plan that gives you this much flexibility and control. Now, most importantly, if you have a loved one with special needs, you can leave them an inheritance without disturbing their valuable government benefits. Now, a trust can also help you avoid or minimize estate taxes. The federal tax exemption is over $22 million for a married couple, so most of us really don't need to worry about that. But Massachusetts will tax their residents with an estate tax if they die having over $1 million in assets. So by properly planning, you can either eliminate this tax altogether or significantly minimize it. Now, if you live in New Hampshire and you're a New Hampshire resident, you don't have to worry about an estate tax because as the law currently stands, New Hampshire does not have an estate tax. So now that I've laid the foundation for you about what a trust is and how a trust works, I want to take a moment to talk to you about Medicare and Medicaid planning. So Medicaid planning is using the tools and strategies that are legally available to you under the law to keep some or all of your assets in your family while still becoming eligible for Medicaid to pay for your long-term care in a skilled facility such as a nursing home. Now, I want to take a minute to explain to you the difference between Medicare and Medicaid. Now, people often get confused between these two programs. So Medicare, ARE at the end, that's health insurance for those over the age of 65 or for those with a disability, but it does not pay for long-term care in a skilled facility such as a nursing home. That brings us to Medicaid. Now, Medicaid is a joint federal and state government program that pays for long-term care if you are eligible. It is one federal law interpreted differently and administered independently by each and every state. So how do you become eligible? Well, amongst other criteria, Medicaid uses a resource test. Now, if you're single, you can only have $2,000 worth of assets in your name, a little bit higher, $2,500 in New Hampshire. If you have a home, you'll need to sell it in order to pay for your long-term care costs. Now, if you're married, you can't have more than $130,000 in assets. And if you own a home and the healthy spouse is living there, then the house is not countable. However, and listen closely, if that healthy spouse either goes into a nursing home or passes away, a lien may be placed on that home. Now, if incapacity planning is something that is important to you so that you can keep some or all of your assets in your family, if you become ill and in need of long-term care, then you need to plan ahead for it. And there's two different types of trusts that are used for this, an irrevocable trust and a revocable trust. Now, these two types of trusts can sometimes be confusing to people. So I want to clarify them for you. An irrevocable trust right here with an IRR, that's the type of trust that you cannot change. A revocable trust right here on this side, that is the type of trust that you can change. Now, I know that estate planning is something that's important to you because you're taking time out of your life to watch this video right now. So a good way to think about your options is to picture that you're standing in the front of these two doors. Now, do you choose the doorway on the right that leads you to implement an estate planning strategy that involves an irrevocable trust, or do you choose the door on the left and go with a revocable trust? So let's talk about first what happens if you choose to go through the door on the right and you choose a Medicaid planning strategy with an irrevocable trust. An irrevocable trust would be the type of trust where you put all of your assets into it. You wait 5 years, and after 5 years, it's as if you've never even owned them. And at this point, they are 100% protected, and the assets are not counted in determining whether or not you qualify for Medicaid. And that sounds great, right? So why wouldn't everyone just want to do this? Well, unfortunately, it's just not that easy. And like everything in life, there's a catch. And it's the things that you're not going to hear about on the radio or from your friends. So first, if you want to do it right, you should not be the trustee of the irrevocable trust. You should name someone else. That means that you're giving up control of those assets to someone else, and you are not required to follow their directions, and they're not required to follow your directions. Second, you absolutely cannot be the beneficiary of that trust. So even if you need the money from the trust, you have no right to demand it, and the trustee has no authority under the trust to give you the money. So you give up control, you give up the right to spend the money in the trust. Now, some people can live with that. Maybe they have a child or a loved one that they trust implicitly, and they have no issue putting them in control, and they know that they're going to do the right thing. But the biggest reason that people elect not to do an irrevocable trust is that depending on what assets you own, there can be significant tax ramifications to putting your assets into an irrevocable trust. And that's an analysis that is extremely important because you'd like to avoid the crushing costs of nursing home care, but do you want to incur tons of taxes now to cover what circumstances that may or may not happen down the line? Now, I'm not saying that irrevocable trusts are bad, quite the opposite. We do them all the time, and if drafted correctly, they work and they can really protect a lot of your hard-earned assets for your family. You just need to make sure that you go into the trust with your eyes wide open and you make a business decision on whether this is the right choice for you at this point in your life. So that's the irrevocable trust, but there's an alternative approach that you could do Medicaid planning with a revocable trust. So the other option is to choose the option on the left, where you're using a strategy involving the use of a revocable trust. A revocable trust is the kind of trust where you're the trustees, the beneficiaries, and you can make any changes to this at any time. Now, the first thing that may jump out at you is, whoa, a revocable trust. But I've heard that you can only protect assets with an irrevocable trust and then wait 5 years. And I want you to listen carefully, as I don't want any of you telling everyone that you listen to this webinar or this on-demand presentation, and Attorney Longtin said, we can put assets in a revocable trust and they're protected from the nursing home, because I'm definitely not saying that. So I want you to listen carefully. Planning with a revocable trust is a completely different strategy than planning with an irrevocable trust. When you put a revocable trust in place, you're giving your family the ability to protect assets if the moment comes that you become incapacitated or ill or in need of long-term care. See, you need to understand that very often at a point of crisis, the point when someone is about to go into a nursing home, there are various options available to protect some, if not all of your assets at that time. Not 5 years before, but at the time that the crisis actually arrives. The problem is that without a proper plan in place, when tragedy strikes and you have a stroke, there's no way for your spouse or your children to be able to use these strategies to protect your assets because you never planned ahead and gave them that option. Now, with this option, you're giving your family the tools to keep some or all of your assets in your family while using the legal strategies available under the Medicaid law to become eligible for Medicaid, which will pay for long-term care costs in a nursing home. So as you've seen, a living trust gives you far more control than any other estate plan. For example, a living trust can help avoid probate at death. It can prevent court control of assets during an incapacity. It can give you the ability to protect some or all of your assets from the expense of nursing homes. It provides maximum privacy. It allows a quick distribution of assets to your beneficiaries. It lets you keep assets in the trust until you want your beneficiaries to inherit. and it prevents unintentional disinheriting, and it can help you reduce or eliminate estate taxes if you're married. So as good as a living trust is, remember it can only control your assets. A good estate plan will let you keep control over your financial and medical decisions. So let's look at some documents that pertain to medical decisions and see how much control that they actually will give you. So the first thing I want to talk to you about is a living will. And although the name is similar to a living trust, it does something very, very different. A living will allows you to communicate your specific wishes regarding end-of-life decisions. Now, carefully considering your desires regarding life-prolonging procedures and clearly communicating them to your family or your chosen medical decision maker is absolutely imperative. Because without these instructions, your medical decision maker will be forced to guess at what it is that you want. And not only can this situation be very stressful for your medical decision maker, it can also be a breeding ground for disagreements amongst your loved ones if their opinions differ. Now, in New Hampshire, a living will is valid and enforceable, and in Massachusetts, your physician is under no legal obligation to follow it, but it's still very good to have it in writing. Now, your healthcare power of attorney allows you to name a trusted healthcare decision maker to communicate your healthcare wishes or make medical decisions on your behalf if you're unable to do so. And if you do not formally choose a medical decision maker, your loved ones will have to ask a judge to appoint someone to make medical decisions for you. And the person appointed might not be the one that you would have chosen. And in addition, the court process is public and it takes time and money during an already stressful period. So let's talk about HIPAAs. That's Health Insurance Portability and Accountability Act authorization form, or as you would have heard of it, a HIPAA. So in a HIPAA authorization form, you grant the named individuals the right to receive information about your medical condition. For example, to get a status update on your condition or receive test results. And although these individuals have the right to obtain information, they do not have the authority to make decisions on your behalf. That power belongs to the decision maker that you named in your medical power of attorney, or the person who is appointed by the court if you didn't have a valid medical power of attorney in place. Now, providing information to your loved ones can help calm the anxieties and the uncertainties that often arise during times of emergency. The HIPAA authorization can also help alleviate any tension between the person that you named as your medical decision maker and the rest of your loved ones, and allow them to at least understand why those decisions were made. So now I want to talk to you about your financial power of attorney. In a financial power of attorney, you choose a trusted person or agent to handle financial transactions such as signing checks or opening bank accounts or signing a deed for you. And if you don't formally choose someone to make financial decisions on your behalf, your loved ones will have to wait for a judge to appoint someone with absolutely zero input from you. Now, it's important for you to know that a power of attorney is only valid when you're alive, and it will cease to be valid upon your death. Now, if you do not have a medical power of attorney or a financial power of attorney in place, then your spouse or your children or a loved one will have to go through a living probate process, which is a court process where a judge appoints someone to make medical decisions for you and appoint someone to handle your financial affairs while you're alive, but just unable to handle them for yourself. So if you're too ill or disabled, who's going to handle all of these daily financial matters for you? Who's going to make sure that your gas and your electric bills are paid? Is it going to be your wife? Would it be one of your kids? Would it be another friend or a relative or someone that you live with? Well, and the truth is, if you haven't given someone the legal power to do this, the judge will decide who that person will be and how your money is going to be spent. The court process is designed to protect those who are incapacitated, and the judge will order that this person's funds be used for their care, oftentimes nursing home care, limiting the family's ability to protect assets when an incapacity actually takes place. So I'm sure after hearing all of this information that you may have some new realizations about what matters most to you. when it comes to your estate planning. So I want to go over with you what you should know about choosing an estate planning attorney. So first and foremost, you want to work with a law firm who takes their time and really, really listens to you. You want to work with an attorney who feels right to you. Now, it's often hard for all of us to gauge whether a new person that we meet is looking out for our best needs. So sometimes we just have to trust our gut. And you also want to make sure that you work with a professional who doesn't charge you by the hour. You need the ability to call your lawyer without fear that you're going to get some outrageous bill after the fact. And you want to make sure that you work with a firm that not only helps you with your funding, making sure all of your assets fall under the umbrella of your estate plan, but also creates long-term relationships with you and your family and is there to offer ongoing support. So we have a package here that we put together, our estate planning package. We call it Longtin Law Legacy Plan, and it addresses all of the major components that people and families are typically concerned about. It offers incapacity protection. So it will protect you if you become disabled and you can't manage your affairs. It will completely eliminate guardianship or conservatorship court proceedings. It also contains HIPAA authorization forms to authorize disclosure of your medical information. And it gives your family the ability to protect some or all of your assets when you become incapacitated. It offers probate and tax protection, and it protects your family from having to go through probate when you die, and it maximizes your protection from estate taxes. It also protects the inheritance of your children should they get a divorce, or if they're sued or irresponsible, or perhaps just struggling in life right now, or if they're a special needs beneficiary. And if your children are not financially savvy, or if they're unable to effectively manage their inheritance, it protects them from their creditors and other related issues that exist with an outright distribution. Now, with all of our clients here, we focus on developing a long-term relationship with them and their families by providing ongoing guidance. So I'm committed to becoming your trusted advisor for you and your family. My primary focus always has and always will be the relationship that I have with my clients and their families. So I love it when my clients call me about all sorts of things and they need advice in other areas of law or just in life. I'm more than happy to help. Because you took the time to watch this on-demand webinar, I like to offer you a free consultation. So normally it's about $450. So I only ask a couple things. So we're notified that you watched this on-demand webinar. So I just ask that you make the appointment within the next 48 hours of watching it, and that you come in within the next 2 weeks. So if you're married, I just ask that both spouses attend, because I'm going to have questions about the goals and your concerns, and therefore it's important that both spouses are there to contribute to that discussion. And lastly, at the end of the meeting, I'm just going to ask you whether to make a decision about whether you're ready to get started and putting a plan together to protect and provide for your family. So either you'll tell me, no, I'm just not ready to proceed today, or yes, I'm ready to get started. No is completely okay. Most people move forward because that's what they're coming in for, so that they can get this in place. So we can accommodate all meetings, whether it's virtual or in person, whatever you feel most comfortable with. So I always like to lay out expectations for my clients. So I'd like to lay them out for you as well on what you can expect at that first meeting. So the meeting will be up to 90 minutes long, and it basically has 3 parts. So I like to start the meeting on time. So if you're coming into the meeting, I just ask that you plan on arriving a few minutes early. If we're having a virtual meeting, then we'll send you the link ahead of time so that you can be prepared to log into the meeting as scheduled. Now, the first part of the meeting is me getting to know you and your family dynamics and the concerns and the goals that you have regarding your estate plan. And every family is unique, so it's imperative that I get to know you and yours and what's important to you so that I can properly answer your questions for you. Now, the second part of the meeting is me answering your questions that you may have. And now that I've gotten to know you, I'll be able to answer your questions for you and explain how the issues that you bring up specifically pertain to your family and your situation. And then at some point during our meeting, I'll let you know how I think that I can help you, if I can, and then you'll decide whether or not you're ready to get started putting a plan in place for your family. So next, I just want you to think about your goals and your objectives. When you meet with me, if you have any questions, make sure that you're working with a qualified estate planning attorney, and just really make sure that you're doing the best you can to be able to take care of your family. So remember, the hardest thing that you have to overcome in order to make all of this happen is procrastination. And you've taken the action that it takes to register for this on-demand webinar and to watch it and participate in it. So let us just help you keep that ball rolling so you don't continue to put off this very important matter. So I want to thank you for taking the time to watch this. I hope that you found it beneficial and that I was able to help you realize the importance of having a proper estate plan in place to save you and your family time and anxiety and money. So let me help you leave a legacy of love for your family and not fear. So you can also follow us on social media. So we are on Facebook, Instagram, LinkedIn, YouTube, and on our website, we have a ton of educational videos in regards to estate planning. So you can also sign up right here on our website. You can also sign up for our newsletter so you can find out everything that's going on. So I want to thank you all for watching. And if you have any questions, please reach out to us. And I look forward to meeting you.